Hello, everyone. This is Scott Schneider from beautiful downtown Austin, Texas, where life is completely back to normal. I am a partner in Husch Blackwell's higher education group, and I'm excited to be teaming up with the impeccable Pete Land. Be talking with you all today about the impact of the final Title IX regulations on faculty and employees. Before we begin, I would like to cover a few housekeeping items. First, I'm grateful to be doing this remotely because I have yet to brush my hair today and otherwise look slovenly. Second, and more importantly, at the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your questions via the question box. We're trying to cover a lot of material in a short period of time, but we'll try to answer your questions as best we can. If you want a fuller answer or we run out of time, it's my understanding that you could send an email directly to Pete, right, Pete? And he'll answer all of those questions. No, seriously, if you don't answer the question, we'll capture it, and I promise we'll send out a response to your questions. We truly appreciate audience participation and encourage you to submit questions. There's also an icon to assist you with your viewing preferences. Accordingly, please note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area, or by dragging the bottom right corner of the slide area. If you have any technical difficulties, please call Pete on his cell phone. That number, I just want you to write, no, I'm kidding. Please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. The program is approved for Illinois, Iowa, Missouri, Nebraska, and Tennessee continuing legal education credit and HR Certification Institute and Society for Human Resources Management recertification credit. The great state of Texas and Wisconsin, we have CLE credits pending. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. You may also download the certificate of attendance from the certificate widget at the completion of today's program. A recording of the webcast, for better or worse, will be available for tomorrow for watching and sharing. Once available, the link to that recording will be emailed to you. Again, as I've mentioned at the very beginning, joining me today is the impeccable, the great, the wonderful colleague of mine, partner in the Chicago office of Husch Blackwell, Pete Land. Pete concentrates his practice on serving private and public sector higher education institutions and academic medical centers in a wide array of litigation and counseling matters, including employment and student disputes, drafting policies, and providing training and guidance to key personnel and students. If you go to the website, you will see this picture of Pete and myself. I will tell you right now, this is false advertising. This is a better depiction of what the current version of Scott Schneider looks like. And after reading the Title IX regulations, this is a more accurate picture of the great Pete Land. And so with that as backdrop, we're going to jump right into it. Pete.
Well, thanks, Scott. And for those of you who've never had the pleasure of trying to follow Scott's awesome introductions, I suggest you devote yourself to that in the future. It's quite a good time. Now that I've put my head together, and after Scott and I have talked with each other about the complex issues at play here with the new title regs for so long, as well as with a variety of our connections on various campuses, it's very nice to be sharing our thoughts with all of those tuning into this webinar. So thanks so much for joining us. We're going to focus on trying to understand the soon-to-be applicable Title IX procedures alongside Title IX procedures as they relate to employee populations. And to do that, we thought we'd start by summarizing what the new Title IX rules and regarding procedures are for sexual harassment concerns about employee behavior. Our discussion today assumes that people are generally familiar with the basic procedural structure that's called for under the new Title IX regulations, you know, formal complaint, investigation, hearing with live testimony, cross-examination, and a required appeal. So we're not going to go through those at great length. We will instead focus on some of the nuances that relate to employee issues. I should start also by noting that if you've read the DOE's commentary and the rules, they span about 2,000 pages. They contain nearly 300 references to Title VII and about 50 plus pages devoted entirely to describing the employee process issues and standards that are implicated by the Title IX regulations. What Scott and I are going to seek to do today is to distill all of that content down into essential ideas and suggestions for implementing standards on your campus that comply with the overlapping nature of the Title IX and Title VII frameworks now. So we're going to try to present our ideas after talking with various folks to help make it clearer for everyone. First, there are three essential concepts from the new regulations as listed here. They impose more procedural requirements, many of which are contrary to common human resources or faculty administration principles for addressing sexual harassment or other discrimination concerns. Second, they only apply to complaints raising allegations that satisfy the new Title IX definition, which I think we all know is quite narrow as compared to pre-existing sexual harassment definitions. And third, the regs and the commentary go out of their way to clarify that Title IX standards and processes that we're all used to, they're all still valid, that they can't be changed by the Department of Education, and that schools can continue to use such processes, but must do so in tandem with the new Title IX regulation procedures where applicable. Now, the where applicable part of that is the challenge that leads Scott's bearded sage pick and my head to be exploding, and we're going to try to address that here today. To address that challenge, it's helpful to start and consider what the new regs do to our new employee processes. So as an initial matter, they have different standard for what type of knowledge we must have of potential sexual harassment to trigger institutional response. As quoted here, the Title IX regs require actual knowledge and direct us to respond without being deliberately indifferent, as opposed to the employee standards we're used to under Title VII that could hold us liable if we should have known about such harassment and did nothing. We'll talk more later about how that standard impacts analysis of how to adjust existing procedures. Under the new regs, harassment must also occur within an educational program or activity and in locations or circumstances in which our institution exercises substantial control. To some extent, other harassment protections may be broader than that. We'll talk about that as well. The new Title IX processes, well, they also only required if there is a, quote, formal complaint, and that formal complaint is about Title IX defined sexual harassment. And there are two parts of that here, and they're addressed in this slide and the next slide. First, the formal complaint must be a document, not just a spoken concern or complaint. The document has to be signed by the complainant or by the Title IX coordinator that requests an investigation. That's what the formal complaint has to do. At the time that complaint is filed, the complainant must be a current participant or trying to participate in an education program activity, such as a current student, faculty member, or employee, or someone applying for that kind of status. If the person only has a former connection to our school, they cannot file such a formal complaint or invoke the Title IX process for a claim of sexual harassment. Second, the sexual harassment at issue in the formal complaint from the current participant in our programs must allege conduct that satisfies one of these three listed concepts. First, if they allege a quid pro quo issue, in which the complainant receiving something positive, an aid, a benefit, or a service from our institution is conditioned on unwelcome sexual conduct. We're all pretty familiar with that. It can also apply second to what amounts to what we all think of as a hostile environment type of set of conduct, but more narrowly defined to require severe and pervasive and objectively offensive conduct, rather than the severe or pervasive standard we're also used to. And third, sexual harassment under the new guidelines for Title IX can apply to conduct that implicates a VAWA crime, such as those that are listed here. Now, if all those conditions we just described on the past two slides are present, then the Title IX process continues, and there must be an investigation which gathers evidence, and that evidence be shared with the parties, followed by a live hearing at which both the parties and witnesses testify and are subjected to cross-examination by an advisor for either party. Obviously, that is a new requirement. Also new and very relevant for our discussion today is a provision in the new regs requiring that if a party or witness is not present to be cross-examined or refuses to be cross-examined at the hearing, we must ignore every statement from that person in reaching a decision about whether there's a policy violation. And we also must not draw any negative inference from the person's absence or refusal. This means that under Title IX processes, we may need to ignore material evidence collected during an investigation because it wasn't tested at a hearing. That's how I think of it. That's a very different concept than any prior standard any of us have had to apply to potential sexual harassment in employee-based processes, and something we'll have to talk about how to implement. Another concept to keep in mind are comments from the various commentary from the DOE. As they were articulating new standards and clarifying that they apply to concerns raised about behavior by faculty, staff, and other employees, the commentary also directly addressed the overlap with Title VII standards. Now, these quoted provisions are a sampling. They acknowledge that Title VII assigns us different legal obligations, that we now must address two different definitions of what constitutes sexual harassment, that we must comply with both, and it concludes that there is no inherent conflict here. Scott's going to share some thoughts about that concept in a moment. But the comments also address two procedural concepts as illustrated in the last two bullets here. First, schools may engage separate processes to address Title VII discrimination, including sexual harassment, quote, when the conduct does not meet the definition of sexual harassment, unquote, under the new Title IX regs. And second, procedures or rights created in faculty handbooks, collective bargaining agreements, or other employment contracts can still be applicable, but they need to try to comply with the new regs. In other words, the new regs go out of their way, really, to tell us we have a lot to work to do, because we now have two legal standards with which to comply that can and are expected to involve different procedures for handling complaints. And with that, I'll turn it back over to Scott.
Thank you, my friend. So I think Pete alluded to this a moment ago. I will be a little more, I'll be direct, just because the Department of Education says there's no inherent conflict between the 9 regs and our applications under Title VII. That doesn't necessarily make it so. I'll start with kind of the practical, I think, complications here. And, my background is when I started as a lawyer way back in the day, all I did exclusively was labor and employment law. I've taught labor and employment law, et cetera. And typically when you get a complaint as a practical matter that implicates Title VII, let's say you're working at a Walmart and somebody at Walmart accuses a fellow employee of engaging in sex harassment, how does Walmart comply with its obligations under Title VII? And so typically what would happen for almost every employer is you'd go through some sort of internal investigation, be a single investigator model. That investigation would be initiated based on a formal complaint, but also, look, it's what should we have known? So maybe even informal information or keeping our ears open. There's certainly in that process, if you go to Walmart and you say, I'm the employee, I'm accused of harassment, I demand to have my advisor present during this investigation, I suspect you'd be scoffed at. So there's no advisor requirement, certainly in Title VII, and it's an unusual thing. Resolution doesn't require an active complainant. We would give training 15, 20 years ago, and the question would come up, if someone complains about harassment and tells me, but I don't want you to do anything about it, could you respond by not doing anything about it? And the reflexive answer was, well, of course not, no. We have an obligation to remediate harassment that we know or should have known, and there's no formal active or formal complaint requirement that initiates that obligation. In contrast, the Title IX regs, obviously, as Pete alluded to, contemplate investigation, which is fine, although a very regimented investigation, which includes reports, and information sharing and all these sorts of things that are certainly not required by Title VII. And also at the tail end, a hearing process, which again is not contemplated by Title VII as well. Formal complaint initiates the Title IX process. You're entitled to an advisor in that process, entitled to an advisor who is doing active questioning at a hearing, cross-examination of witnesses and the parties. You need a participating complainant, and it requires formal reports and other documentation. Some big picture legal principles, and I promise you we're going to do some hypotheticals and talk through them, which I think, I don't know that we have all the answers, but at least I think can point you in the direction of asking the right questions institutionally as you try to merge your existing Title VII policies and processes with these new regulations. A couple of things, and again, I feel like there's a little bit of overlap here, and Pete alluded to this. Under Title VII, our obligation is not triggered with a formal complaint. It's what we know or should have known about sex harassment. The definition in Title VII of what is actionable sex harassment is different from what's in Title IX. There's a or component to that, and in some of these hypotheticals, we'll explore some possible issues in that regard. In addition, we typically think it's a good practice not to wait until harassment becomes illegal, unlawful, severe, pervasive to start intervening, and we're certainly entitled under Title VII and probably encourage to do that. I already alluded to this, no hearing requirement in Title VII, but this is, I think, the biggest one and where a lot of the potential issues will come up, and you'll see this, I hope, in the hypotheticals. The one thing that is unusual about I think the most troublesome reg among the Title IX regs is the hearsay rule, which, again, Pete alluded to, which basically says we may learn something in the course of an investigation, a witness statement, or whatever the case may be. And if that person doesn't show up and subjects themselves to cross-examination, we must ignore that out of court or out of hearing statement. No, typically in a civil trial or a criminal trial, there are even exceptions to the hearsay rule. None of those apply here. If it's not made in the hearing, a statement, you need to ignore it in the Title IX process. I don't think, I'm quite confident in saying that there's no guidance from the EEOC or case law interpreting Title VII which applies this rule of evidence and, more importantly, would allow an employer to apply this rule of evidence, to ignore evidence, in essence, gathered in the course of an investigation. And we'll talk about that in the context of hypotheticals. Last piece is, and this is a big legal principle, for about 200 plus years, we've recognized the employment at will doctrine, especially for my friends at private universities. And the idea here is I can fire someone for any reason and utilizing any process I want to, so long as it's not for an illegal reason. And Title VII gives us some restrictions on the reasons why we can't fire someone for race or sex or whatever, but there's nothing in 7 which addresses the how question. It doesn't tell us, outside of promulgating policies and following up on complaints and investigating, it doesn't get into the weeds about how we must discipline or formal hearing rules and formal evidentiary rules and all that sort of stuff. The 9 regulations clearly do. I had a conversation last night. I said it is interesting to me that the Department of Education, pursuant to a statute passed in 1972, which is a fairly modest provision prohibiting sex discrimination, has arguably modified the at-will employment relationship in terms of dictating the hows in which even private institutions must go about disciplining employees. A couple more legal principles that we'll talk about, and I think may prove to be interesting as we start getting into the weeds of some of these hypotheticals. There is a circuit split about if someone believes that they have been a victim of employment discrimination, whether they can pursue those claims through Title IX or whether Title VII is the exclusive remedy for employment-related sex discrimination claims. I'm in the Fifth Circuit. It's wonderful here. It's 80 degrees. People are having a good time, all that sort of stuff. But in the Fifth Circuit, we have said if you want to file an employment discrimination case against a university, you're stuck with Title IX, with Title VII only. You can only bring a Title VII claim. And so in terms of kind of deciding, if there's ever a situation where there is tension between our obligations to comply with 7 and our obligations to comply with 9, the fact that someone might have a cause of action under 7, a legal cause of action, a claim, a lawsuit, and may only be entitled to agency relief or a complaint to the Department of Education for violations of 9 may prove to be part of the calculus we go through in trying to decide how we resolve that, any sort of tension. Last, and Pete alluded to this, I'll just add one little layer to it. Obviously, the Title IX regulations are limited to a fairly narrow set of sex discrimination complaints. Title VII is broader, both in terms of the sort of sex discrimination that is captured by the statute, not just in terms of sex discrimination per se, but also the definition of what constitutes actionable harassment, but also obviously includes other protected categories not contemplated by Title IX. And we'll talk a little bit about how the intersectionality or potential intersectionality of some of these claims might prove to be complicated. I don't know, I'm going to chip in quickly on this. One of the practical considerations here, and I think obviously the regs and the preamble to the regs, I think gave short shrift to precisely how complicated some of the practical issues associated with this may prove to be, especially in a time where a lot of our institutional energy is directed at solving probably one of the most difficult risk management and practical problems of our lifetime in responding to the pandemic. So one of the practical issues here is the Department of Education is basically saying if you have collective bargaining agreements, for instance, that have a different policy or process for these sorts of Title IX related claims, we need to go and renegotiate those. You better do it, by the way, before the effective date of August, 14th, 15th. Well, it's easy to say. It may be a lot more difficult in practice to do that. Same thing. I've worked in-house at a university. I've worked out-house for universities. It ain't exactly easy, and it's not quick. It's very difficult to quickly change institutional policies, especially around something like this. Now, you may be able to draft interim policies that are effective until there's a final approval, but typically that process of getting a policy drafted, approved by all of the relevant stakeholders, that's a time-consuming and frankly exhausting process. But the idea here is, look, Department of Education says you got to move forward. You need to comply, and I don't think they'd say much of anything about sort of the practical implications there. Pete, did you want to weigh in quickly on the expert witness portion of this? I know you had mentioned it before.
Sure. I think what's worth mentioning here is that litigators are used to expert witnesses. Internal university or institutional processes just are not. They've never been really part of any process that I've been a part of on an internal system and of investigating complaint or concern. And under the Title IX regs, the hearing and investigative processes can include expert witnesses. And I think dealing with something that's that new and that can involve the level of complications that can come with that will be very challenging for institutions to deal with. These are not witnesses that are talking about things that happened. They'll be witnesses who are, they're not fact witnesses. They'll be talking about what those facts mean or how to interpret them in some context. And while they might be helpful to deciding some issues, trying to figure out which parties to allow to have what experts, and then whether the experts are actually qualified to provide the opinions they provide, all of those issues I think will just raise challenges for the Title IX processes. And like the risks with tensions between Title IX and Title VII that Scott was talking about before, about how you can get sued or how you might not, that trying to deal with a process that involves expert witnesses gives you one that says, maybe when I don't have to, I'll try to find a way where I use the Title VII processes if I can. So that's why we include it here.
All right, this is the last ARI slide that we're doing today, and then we're going to get into some hypotheticals that I think do a good job of illustrating maybe some of the challenges here. Look, this is the way I think of this. I actually even drew, I did it on a computer, this it's really bad. Is this a Venn diagram, Pete? Is that what this is?
That is.
So,
it's a Venn diagram. Very good.
And we could have gotten crazy with it. I mean, we could have added, race and all these sorts of things. But long story short, there are cases where, for definitional reasons, because we don't have a formal complaint, because it didn't occur, harassment didn't occur within the context of an educational program or activity, there are cases where we do not have Title IX obligations, but we do have Title VII obligations. And, in my way of thinking about this, those are sort of the easy cases here. We are not obligated when we have a pure Title VII issue that, doesn't meet the definition of sex harassment, et cetera, for the Title IX regulations, we don't have to comply with the Title IX regulations in that space. And that's a pretty broad category of potential issues. We then have the area where it's more complicated and where there are overlapping responsibilities. There are parallel Title VII and Title IX obligations. And I won't, I think we've done a good job of explaining when 9 kicks in, but yet when we have a formal complaint of definitional sex harassment, it's occurring within the context of an educational program or activity, someone in the United States, et cetera, we're going to have 9 obligations pursuant to the regulations. But we also have obligations under Title VII as well. And I think it's when those two areas cross and we have dual obligations that things, despite what the department said about there being no inherent conflict, things get a little complicated. And so what we're going to do now is stop talking about legal principles and things like that and sort of demonstrate the concerns by discussing some hypotheticals. And then we'll give some thoughts about sort of the questions that as you draft policies and consider processes, we think you should be asking, and may even towards the end have some suggestions about what we think is a reasonable way to proceed. So here's the hypothetical. Are you ready for this, Pete?
I am.
It was cleverly titled Hypothetical 1. I'm very creative. I'm a very creative guy. So here's the hypothetical. Employee A complains to Human Resources that coworker employee B sexually propositioned A on one occasion at work. Employee B denies the allegation. Employee C corroborates A's account. All right, so that's the hypothetical. Again, very creative names as well. Here's my first question for you, Pete. Is Title IX implicated here?
So I think that based on the facts as provided here, it does not seem so. I say it that way because employee A is a current employee, but alleged conduct that only involves one occasion, which would not be pervasive. And based on what's described here, it's unlikely that it may even be severe either, unless you gather more detail about exactly what the nature of employee B's request for sexual conduct entailed. So when it's not pervasive, though, we know it can't be severe and pervasive, so it doesn't fit under Title IX. However, again, if you learn more information about the nature of the request, it could have been a quid pro quo type request if it was tied to any kind of employment benefit. And if that were the case, and there were also a formal complaint that had been filed, then it may be something that would need to be dealt with through the Title IX process.
Yeah, agree. So let me add, would this be the sort of typical Title VII harassment? Would this be the sort of case that a Title VII harassment policy would cover?
Yes, I think so. I mean, it's in the sense that it would call for this to be investigated to determine whether the request, the sexual proposition, created a hostile environment, again, or if it involved a quid pro quo situation. But based on these limited facts, it may still not be severe or pervasive, and thus not a violation of Title VII sexual harassment standard. It may not be. You'd want to investigate it. So it would implicate the policy to determine if it were, and the nature of the conduct. But the harassment policies, as we all know, they often seek to curb harassing behavior that falls short of a legal definition of sexual harassment, and it may include, many of your policies will include addressing unwelcome sexually charged behavior like this, especially where we see employee C's corroboration that this happened. It may be enough for a policy violation finding and or disciplinary action for conduct that is sexually charged, it's unwelcome, and it may fall short of what the sexual harassment definition is, but it's still something we don't want to happen in our workplace and don't want people subjected to, and our policies allow us to address it. So I think it would. So it could.
I'm going to get you the third question, and I think you've already answered this, but I want you to do it one more time. How should the institution respond here?
Yeah, I think this moves a little bit into how these policies overlap and steps we'll have to take. So that we haven't before. And the first thing to do, I think, would be to document why the Title IX sexual harassment process does not apply and why we are following our usual or Title VII harassment policy, protocols for investigation and that allow us to tailor to the circumstances. So we'd want to follow those processes, and then we'd want to address any violation under the existing harassment policies. But you'd want to be documenting why the additional bells and whistles of process that might be perceived as protecting a respondent wouldn't apply.
Right. And this, by the way, presupposes something that I think will develop into a practice, and we'll talk about in a moment, which is that we will cabin off the 9 process and procedures only to, or as much as possible, to the 9 related claims, and have different policies and procedures for those things that do not meet the definitional standard. That will be a question I think schools need to wrestle with, is that one, and we'll talk about it in a little more second. Are you ready for hypothetical number 2, Pete? And look, I didn't know how you were going to answer that hypothetical, and I was a little worried. You did great.
Well, thank you.
You did a great job. I appreciate it. All right, employee A goes to Human Resources to express concerns that supervisor is making sexual comments to employee B on a regular basis. HR reaches out to employee B, who confirms the sexual comments but says, I don't want you to do anything about it. I'm not filing a formal complaint. All right? So here we go. Question number 1, is Title IX implicated here?
Again, I think the answer is probably not. Employee B does not want to be a complainant, won't file a formal complaint, doesn't want an investigation. seems likely we're going to lack the formal complaint and request for an investigation. Now, there's still a chance that the Title IX coordinator, upon reviewing any allegations, could consider filing a formal complaint. And the issue here where there's a regular basis of comments could meet the pervasive idea, but depending on the content of those comments, it could be severe, but there's no indication here so far that it would be, and there's no indication at all of any quid pro quo. So without more, it seems unlikely for the Title IX coordinator to proceed with filing a formal complaint because it doesn't seem to meet the Title IX definition of harassment.
Okay. Is Title VII implicated here?
Yeah, I think we know here that it really is, and we know, of what appear here to be regular or assuming they're unwelcome sexual comments. We'd want to clarify that within the workplace. And it's coming from a supervisor, and 2 employees have identified those comments as having happened and have heard them, and I'm assuming in the hypo that they're both not liking them. So the pervasive nature seems to satisfy the Title VII definition, at least enough we would need to understand if it's changing the environment for either employee A or employee B, enough for it to be a policy violation. There's also some clear concern. This is the kind of hypothetical or scenario we learn about where we're worried about other people too, and whether they've heard these kinds of comments and whether they could pursue some action against us if we don't do anything now that we know about it to stop the supervisor from addressing people in this way and to address the concern. So, this is exactly the kind of situation where we'd want to make sure that we're following our existing Title VII policies and investigate and understand what's happened and do something to address it.
So this is our first, segment where we sort of transition and give you a little practical guidance. And let me just say this. I think there's no one size fits all, and I don't care if anybody markets that sort of policy. Each institution is going to have to basically sit with these issues and decide institutionally what makes sense from a principle standpoint, from a process standpoint, from a, what sort of resources we have standpoint. To me, one of the initial questions that schools need to be asking themselves, and you sort of see hints of this in the 2 hypotheticals we just did, will we apply the Title IX rules and procedures to all allegations of sex discrimination and other Title VII related discrimination, race, color, national origin, all that sort of stuff, regardless of whether they are technically covered by the 9 regs? Or will we have a separate standalone policy and process that applies only to those sorts of claims in which the Title IX regulations are implicated? All right, so I think that's the first threshold question. And I would say, and I don't know if Pete feels differently than me, that at least the conversations when we talk about it, I think it makes sense to have a separate standalone policy that applies to that subset of harms covered by the Title IX regs, and maybe not make that part of those policies and procedures, probably not make that a part of misconduct that doesn't fit the definition of the Title IX regs. Other people may have different approaches to that, but I think that's one of the threshold questions that schools need to be asking themselves, assuming we have different rules and procedures. In other words, we have one category of cases that will go through the Title IX procedures and a separate that will go through our normal anti-harassment policy and process. Pete sort of alluded to this. How will we clarify up front, both in terms of documentation and meetings with the alleged victim of discrimination, et cetera, et cetera, et cetera? How will we clarify up front that the nature of the sex harassment allegation or the sex discrimination allegation does not fit within the Title IX policy definition? What are the practical things in which we will be doing? The other thing is what happens, and Pete sort of alluded to this, and I think this is super complicated. What happens when over the course of conducting an investigation, we learn more and all of a sudden, wow, our Title IX policy is implicated? Thinking through those sorts of questions as you draft your policies and processes in response to the regulations. How will we handle sex harassment claims in the absence of a formal complaint? And again, Title IX says we can take a pass. We don't have that sort of pass in Title VII. Again, to me, it screams for possibly the need for a separate standalone policy. And how will we handle complaints from former students and employees, which has been for probably the last 3 years, especially on the former student side, a really hot area nationally, not just Title IX, but in terms of negligence and sex abuse claims and all that sort of stuff. Again, under the Title IX regulations, we would not be obligated to investigate complaints filed by former employees, former students. Would it make sense, nevertheless, for a variety of other reasons, to say, I appreciate that, but we're going to conduct those investigations here as well? And so I think these are sort of pretty good initial institutional decision points that you need to be asking stakeholders, you need to be asking people at the university, and decide how do we want to approach this. You want to do another hypothetical, Pete?
Sure, that'd be great. You want me to read this one and you give us your thoughts?
I like
you ready
this,
for
man.
that?
Yeah, I like it. Yeah, let's do it.
Okay, so employee A reports that the dean repeatedly sexually touched employee A and that this sexual touching was witnessed by employee B. Human Resources interviews employee B, who confirms that dean has repeatedly touched employee A in a sexual and unwelcome way. Employee B, though, says he does not want to get involved and will not participate in any sort of hearing. Fearful of the dean, employee A also refuses to participate in any hearing. How should HR respond in satisfying obligations under Title VII and Title IX? And, you know, that's sort of the ultimate question. Maybe we start, Scott, with, so is Title IX implicated here? And do you think Title VII is implicated here?
Yeah, so I will make it easy. I think both are implicated here, repeated sexual touching and that the sexual touching was witnessed. So I think repeated sexual touching would be severe and pervasive such that it's covered by the Title IX regs. Now, maybe you don't have a formal complaint. I should have made that clearer in the hypo. There was an initial formal complaint which triggered the HR response. So I think Title IX, these are current employees, it's happening at work. I think Title IX is implicated here. I obviously also think Title VII is implicated here for fairly obvious reasons. We're on notice now of potential sexual harassment coming from, by the way, a supervisory employee, which triggers institutional responses, some of which are governed by the Farragher and Ellerth cases, et cetera. But I think both 9 and 7 are implicated here. And so now I'm going to go, can I just read question 3?
Sure.
Man, I'm ruining the whole thing. I'm sorry, Pete. So question 3 is, all right, we say this is covered by 9, and we go, all right, we're going to do an investigation, and the investigation needs to culminate in a hearing process under Title IX. What's the likely result of the Title IX hearing process? When I don't have employee A coming forward to participate in the hearing, and I don't have the corroborating witness coming forward, and we have this rule, this evidentiary rule in the Title IX regs that basically says, hey, if they're not subject to cross-examination, you cannot consider the statements that they made in the course of the investigation or elsewhere. What's the likely result of a hearing on that set of facts? It seems to me that the dean is going to be cleared, and the dean is going to be cleared because the 9 regs are compelling us to ignore information that we learned in the course of our investigation. My concern with that from a Title VII perspective, and this is where my head, your bid emoji was better than mine, my head starts to explode, is I don't think Title VII affords us the leisure of being able to say, we're going to ignore the complaint and the corroborating witness. I think we are compelled under Title VII to potentially reach a conclusion that we do not reach under Title IX and cannot reach under Title IX. And so the question, and we'll maybe I'm skipping ahead just a little bit, and I maybe am a little bit, is, well, how do we reconcile? I mean, they said at the very beginning there's no inherent conflict between 7 and 9. This isn't that far-fetched of a hypothetical, and at least in my mind, I suspect in Pete's mind, we're discerning a conflict here. And the question is, as a practical matter, is how do we go about resolving that conflict? And so with that as backdrop, what number are we on? We're on slide 18. You're supposed to pose this question, Pete.
Yeah, I think we've been talking about these questions here with that hypo, and I think it's helpful to see them clarified in this way. The first question listed here is really explaining a little bit about what should we do about the issue created by the hypo. If a respondent is cleared for a Title IX violation, will the school still consider disciplining pursuant to Title VII? And combine that with, what if the reason for no Title IX finding is the absence of witnesses at the hearing? And I think these go together in the sense of how you think about approaching these things. Because combined, what they mean is you've learned of information, but you're not using it in evaluating whether or not there was a sexual harassment problem here under Title VII. And because the Title IX regs don't allow you to. For determining whether there was a sexual harassment violation under Title IX. And that's where the conflict really meets its breaking point. And there's a reason why we were including information earlier about how the exclusive right in court to pursue an employment claim, if you're the complainant in one of these cases, in many circuits is Title VII, not Title IX. I mean, if we learned of information that leads us to believe there was sexual harassment, but we couldn't use it in a Title IX hearing, and we stick with that result under Title VII, I struggle mightily with what our defense is to that claim under Title VII from that complainant about why we didn't do anything about it. I struggle much less if our answer is yes, we will still consider disciplining under Title VII if they're cleared of a Title IX violation, especially if the reasons have to do with inability to consider information gathered in an investigation. I think what we're balancing is, if we have to deal with an enforcement action from the OCR under Title IX, that seems less likely than and less potentially damaging than and less risky than the Title VII claim from the complainant. Who knows? They've seen this investigative information. They know there was information that shows there was potentially a sexual harassment finding, but there's nothing done. So I think that's the way we come out on how to weigh those risks, or how we would suggest thinking about coming out. How you want to memorialize this in a policy or process is more challenging. I think you want to address it. However you decide to do it in your policy, what's going to happen in these situations? Will you still consider under Title VII or not? And I think we can talk a bit more down the road here about what the process could be, because we have a slide a little later here that kind of addresses that. Guys, do you have anything to add on that?
No, I mean, the only thing I would add is that I think even the administrative action, complaint to OCR, we could probably cobble together a pretty compelling argument. No, we complied with OCR, the Title IX regulations. We did the investigation, we had the hearing, we cleared him from the Title IX finding, but we have another obligation under Title VII, and we reached a different conclusion. There is an interesting provision. I don't know that we're going to have time to go into this now. I know we're kind of coming up on the hour, but there's an interesting provision at the tail end of the regulations, which is nominally called retaliation and includes a lot of things that I don't think traditionally we would consider to be retaliation. It'll be interesting to see whether or not OCR's position about basically reaching one conclusion in 7 and a different conclusion in 9 would be a form of retaliation covered by the regs. But I just wanted to point that one out. Let's do one more hypothetical. You ready?
Sure. Yeah. So I'll read this one for you. So employee A claims that supervisor is subjecting A to pervasive and severe racial and sex harassment. And during interviews, 4 other employees corroborate the claim with extensive, consistent detail. At the hearing, employee A fails to appear. Only employee B testifies. And the panel decides is not responsible under Title IX regs. Investigative report clearly supports a finding of severe or pervasive unwelcome sexual conduct. So what do you think of these questions here, Scott?
Yeah, so a couple of things. 9 is clearly implicated. Definition is met, all that sort of stuff. The intersectionality piece of this is the part that I find interesting. So, it's not unusual for a harassment complaint to be tied to more than sex. And so what about the case where somebody's complaining about sex harassment that qualifies under the 9 definition, but also race harassment? And again, I said at the beginning, we're going to have to make a threshold determination about, do we cabin off the 9 stuff to its own little spot, never to be used outside of what is required by the regs, and leave everything else pursuant to, or to be handled pursuant to, an anti-harassment policy. And I certainly think when it comes to race, absolute clarity that there's no question we can do that. My question, I think the practical question, and it's something you will have to wrestle with as you accommodate these regulations, is what does that process look like? We have the 9 investigation and hearing on one track, and we have an investigation into race harassment on a separate track. And typically, I said Walmart at the very beginning. I mean, if we had an investigation of race harassment or sex harassment going on anywhere in the country that took more than 2 or 3 weeks to resolve from an HR perspective, boy, that would be a long time. And so it's entirely possible that the investigation into the race component will be done way before we're done going through the whole investigation and hearing process associated with Title IX. Does that mean we can terminate the employee if we find, yes, they've engaged in race harassment in violation of our policy? Before having to go through that, would it moot the rest of that? And I think there's a compelling argument that we could ultimately do that. But again, it's one of these things, one of the questions that I think schools should be wrestling with, and I actually say it. I think we say it right here in this slide. Will there be separate tracks for this sort of hypothetical running at the same time? Would you do the 7 investigation before the 9? I mean, that might be another option before we even reach the Title IX related issue. We're going to address and look at the race harassment or the age discrimination component of those. We do it the opposite way. We're going to give everybody their procedural rights under 9. And once that is done, we'll look at these other conduct issues. And then again, what does the language look like? How do we memorialize that in a policy?
Yeah, so we've been asking a lot of questions and raising considerations along the way here, and we, I think, prefaced everything by saying there's going to be challenges for each school to work through in figuring this out. This slide the goal of this is it reflects our thinking about how to synthesize the concepts, the risks, competing obligations we've talked about into some kind of coherent map of a process to consider. We give it to you for your consideration here. So an option would be this kind of 4 different, really 3 steps and then an extra consideration at the end. But first, and how to put this into a policy is something you really have to think about with respect to your individual policies and the different policies that apply to the different constituents within your institution, meaning students, employees, faculty, anybody with contractual arrangements, CBAs, but this concept could be applied. So first, we're thinking it could help to determine, ask the question, do the allegations meet the Title IX sexual harassment definition from a current student employee with a formal complaint? And remembering that the sexual harassment definition or Title IX is narrower than others. And if it's definitely not a Title IX sexual harassment allegation, you can dismiss from the Title IX process. In fact, you have to dismiss from the Title IX process underneath the new regs if that is the case. They require us to do that. But we could also at the same time, once we dismiss from the Title IX process, consider a Title VII process or other applicable code of conduct that addresses this kind of these allegations. If the answer is yes, if they do meet the Title IX sexual harassment definition and meet the others, then we apply the Title IX procedures, even though they're more cumbersome, even though they involve more steps, even though they involve a hearing, where we may or may not have everyone show up. We want to follow that process, and then we'll consider it along the way for both sets of our concerns under Title IX and Title VII. So then at the close of the investigation under either process, if we've decided it's a Title IX allegation, then we still have an investigation. At the close of that, we could contemplate some employment action if it's warranted. The Title IX regs do allow administrative leave. Obviously, our Title VII processes allow us to consider taking steps in an interim way along the way. We consider this kind of at the close of the investigation sort of a hybrid idea to mixing the two together and not just relying on the hearing. Some may consider it to be too risky if you're engaging in a Title IX process to make any kind of employment decision before the hearing, and it may be in a particular case. But again, the regs do allow us to consider administrative leave along the way. They discourage discipline short of a hearing, but if the conduct was so severe and we're concerned about other people having to interact with the respondent, we may decide, or your institution may decide to take that risk. The third step is that if the Title IX process applies and we haven't taken any kind of administrative step along the way, we conduct the hearing, we evaluate the Title IX determination at the close of that process, whether there was a finding under Title IX responsibility or not. And I think that you're always going to want to do that if there is a finding of no responsibility under Title IX, because the definition of sexual harassment for Title IX is so much narrower than under Title VII. One other thought to keep in mind as we go about thinking through this is that it could be helpful to add some, but not all, of the Title IX, I think of it as the procedural bells and whistles, to your Title VII process. I don't think you'd want to include a hearing or the cross-examination concepts or even the expert witness concepts in your Title VII process. But you may want to allow an advisor to be present, silent but present, able to participate in listening and as a support person for either party. You may want to consider adding approaches where you share evidence or a preliminary report with each party under your Title VII process. And the idea is that it adds that due process protections that the Title IX regs are adding. This is particularly true if you're a public institution and could be subject to due process complaints. So it's something to keep in mind. I know it's not a typical human resources approach, but we know of some schools that have been using this anyway before the new regs, and it tends to, I think it's worked out for them when they have. So it's something to think about. Again, MAP is a potential approach. You know, it'll need to be customized to your policies and to your particular campus. But it's really intended to reflect an effort to combine the ability to apply both Title IX and Title VII process principles, preserve the affirmative defenses we have under Title VII, and honor the Title IX regs and their limited definition of sexual harassment and the procedures that they provide along the way. So I have a couple slides here that we want to talk about some other questions that we've received from other webinars and from other communications with folks about employee issues relating to the new regs. So one of the first ones here is if an employee refuses to participate in a human resources investigation of a Title VII claim, can that employee be subject to discipline? And before I get to this retaliation definition, we know that it's very common in our existing policies addressing employees that it's part of their job to cooperate with investigations, to provide information truthfully, and often they're told in various policies they could be disciplined if they don't do that. I think generally we feel like that principle can still be applied, but we have to be mindful of this retaliation language that Scott was talking about. I'm not going to go through all of this here, but because it's pretty dense, but we can unpack some of the language. If you look at it, it seems to include ideas that are not what we think of as classic retaliation concern, because it doesn't seem to require that a person is engaged in a protected conduct that leads to an adverse employment decision so that they can have a retaliation claim. Instead, it reads as if someone's status, and particularly as a respondent, can offer them some protections from other disciplinary processes, particularly if they're accused of Title IX sexual harassment. It seems to suggest we can't use other code of conduct rubrics to deal with the same conduct if it was at issue. But it also includes some language that gives us a way, I think, of determining that it wouldn't be retaliation to use some of our processes for two reasons. One, the other process that's used has to be used to be retaliation, has to be used for the purpose of interfering with Title IX rights and process. And also, the other code of conduct provisions have to lack, I read this as requiring that they lack any sex discrimination or sexual harassment component to the other code of conduct issues. So if we're using our Title VII code, which addresses sex discrimination and sexual harassment, I think we can do that without running afoul of this retaliation function, which means we can use the considerations about requiring employees to participate, in particular if we include disciplinary warnings within our Title VII policies, as opposed our anti-harassment policies, as opposed to other more general policies that don't address sex discrimination or sex harassment. You want to include that warning in the policy that addresses sex discrimination or sexual harassment. This second question at the bottom, can parties be instructed to not discuss investigation with others? Our view of this is it's not a good idea to do this. Generally, the Title IX regs prohibit clearly us from telling parties they cannot discuss the investigation with others, can't issue gag orders. This has sometimes been the approach in other human resources or Title VII related investigations. We recommend using a different approach. I think Scott and I have approached this way for a while, where we try to ask people to protect the integrity of the investigation, indicate it's best if they limit their communications with others, but affirmatively tell them we can't prohibit them from doing so. And candidly, I think people usually end up talking with others if they're accused anyway. I'm not sure how effective it is to tell them not to. So there's risk of applying some kind of gag order approach, and we think when you can, it's helpful to have the same approach to the Title IX and Title VII policies where possible, and we think this is a good example. So the last question I get to, last couple of questions, has to do with at-will employment, status of at-will employment for someone accused of sexual harassment. And Scott touched on this about whether the Title IX new rules limit our ability to terminate an employee who lacks any contractual commitment, who we'd usually be able to determine how we want to terminate them. We think there are mixed answers here, and ultimately the best approach has to depend on the circumstances you're faced with. Title VII frameworks that we are allowed to use will still apply. They still allow termination without the extensive process of people who are in at-will status. But if someone is accused of Title IX sexual harassment that meets the Title IX regs definition, it'd be risky to take a definitive action against them before going through the hearing process. Even though that undermines the at-will nature of their arrangement, we think that'd be risky, and it's worth thinking twice about before you decide how to do it. The last bullet here is just two words, right? State law. We've had people ask some questions about this. The goal of our talk today is not really to address the details here, but to acknowledge that a variety of states have laws that address these issues and address procedural issues that have to be addressed, and the regs themselves go on at length about trying to talk about how they acknowledge the existence of different standards, but say that they can be meshed with the Title IX regulation standards. To do that, the devil's in the details. You want to make sure you're checking your state law. So with that, Scott, I turn it over to you if you have anything else to add.
No, you were awesome. You were awesome. I was C+ today. You were A+ and awesome. Boy, it ain't an easy issue. Is the bottom line. It's a lot more complicated for a variety of practical and legal reasons than the regulations suggest and the preamble suggests. I know there are questions. I haven't had a chance to look at them. I've been entranced with this, and I promise we're going to sit down with the questions and send out an email to the extent we can answer the questions. So that's the end. That's the end of our program. Thank you for joining us for the program today. It was fun. We hope the information provided was helpful for you and your organization. If you haven't already, please click on the survey icon, but only do that if you're going to say nice things about me, trash Pete, whatever you want to do. It's at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. Never let Scott on any of these again. As a reminder, the program is approved for Illinois, Iowa, Missouri, Nebraska, and Tennessee continuing legal education credit and HR certification, yada, yada, yada. Texas and Wisconsin CLE credits are pending. A recording of the webcast will go to my mother. She'll be proud, and it will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you. This concludes our webinar. Thank you, Pete. You're awesome.
Hey, thanks, Scott. And thanks, everybody, for chipping in, and have a good day.
Take it easy.